right, and welcome back. Right now, we wanted to cross over light to the High Court, which has started hearing the case by the opposition coalition NASSE, challenging the award of the ballot paper printing tender to the Dubai-based Al Ghurair Printing. Remember that the Chief Justice David Maraga had appointed Judges Joel Ongugi, George Odunga and Justice Mativo and directed them to hear this matter expeditiously. So let's just cross over there. As you can see, it's already started for us to listen into that.
With your permission, Mr. Thomas will address it.
Okay.
Thank you, my lords. As I think my Lord Judge Mativo has indicated, it will be necessary to first understand, on the basis of a formal application, what the interest of this applicant is, aspirant or candidate, and what it means. So I think we'll reserve our position until a formal application.
For the interested party?
Yes, my lords, on our part, we feel that many other interests have been represented, save for those of the independent candidates. So we have no objection in the adjourning the matter.
The interested party?
No, my lords, I think it would have been far much more expedient if this proposed interested party had said, even orally right now, are they supporting or are they opposing the notice of motion? That would have allowed that interest to be canvassed by the applicant or by the Honorable Attorney General or aligned with any of the other interested parties. So to an extent, my qualification to my life friend Mr. Tomachari's submission is that there is no clarity as to this interested party coming in. We have no patent objection, but it is good to be clear which way are they going, because then they will settle the proceedings unnecessarily.
Okay. As I gather, the sixth interested party is not represented?
Third way alliance.
My lords, All Alliance was joined as the fourth interested parties, together with Dr. Kurapot,
Okay.
as one party.
So six, okay.
Yes.
So there is no such thing as
There is no
sixth
sixth.
party. So, just in view of the public interests and the need to very expeditiously deal with this matter, we are of the mind that we will allow the applicant to be enjoined. He should file his formal applications by the end of the day today, and then he shall abide by all the other directions which we shall give today. Just for your information, the idea is to finalize this case tomorrow. Actually, I should have said yesterday. So in the event that you want to come in, you should be aware that there will be very strict timelines, which you'll have to abide by. Okay? All right.
My lords, perhaps before any further orders are made,
Yes.
there had been some consultation made amongst council.
Yes.
And we had charged our senior counsel here and the honorable senator
Yes.
to make certain proposals to the court.
Okay.
If you do allow Malano friend, Mr. Orengo, he can.
I will allow him to do that just as soon as I write this.
All right.
Okay, Mr. Orengo, we're ready for your proposal?
Yes, subject to your directions,
Yes.
We had a proposal to make.
Yes, please.
And particularly because some of the pleadings were only being filed this morning,
Yes.
and there have been no formal exchange of those pleadings and other documents which have been filed. So subject to your directions, my lords, we were proposing that the applicants should file their written submissions by the close of the day, tomorrow, Wednesday, the 29th of June 2017, and any party who is in the support of the application should similarly file their written submissions by the close of the day, tomorrow, Wednesday, the 29th of June 2017. And that the respondent and other interested parties who may not be in support of the application file their written submissions by the close of day on Thursday, the 30th of June 2017. And then, my lords, 29th of June, yeah, sorry, 29th. My lords, that the parties appear to highlight the submissions on Friday, the 30th of June, 2017, and that again, subject to court's directions, the applicant be given 1 hour to highlight the submissions on behalf of the applicant.
1 hour?
1 hour. The respondent to be given 1 hour, and the interested parties 30 minutes each.
Each, all of them?
Each. And again, subject to your directions, the applicants be allowed to reply to those submissions. My Lord, we did not quite discuss the question of whether other pleadings which a party may want to file. I think probably those should be filed together with submissions if there are any responses. They should be filed within those timelines. I had some little laughter. I don't know whether it was in support or in opposition. But that's what we have discussed. I am sorry that Senior Counsel Mr. Ngate was not here when the discussions were going on, but the rest of the party was there.
It's not the rest of the team.
The rest of the team was here.
Your team.
Yeah.
I don't know. Could we put a contraposition because we were not party to this discussion?
They were. Your team was part of it.
Mr. Gatonyo, I'm addressing the judge. There are, of course, allegations made against our client, and the suggestion we will do is, put is this, Lord. The applicant has had quite a bit of time to prepare for this case. To again be given the remainder of the day today, the whole of tomorrow, for them to do written submissions, is to give them too much time. Let them put all their papers by close of business today, but not just to file, but to file and serve. Because what is happening, there's a lot of filing and no service. Is to file and serve by close of business today. The kind of submissions we are looking for, my lords, are not theses or the appearances of theses. Limit them to, say, 5 pages or 7 pages. There's need to limit them because, again, if we leave it open-ended, one writes too many pages of submissions, which will take too long. Let's agree on how many pages. Mr. Kinyanju is saying 12. That's on the higher side, but I was throwing the towel at 12 pages. And what I say about the applicant is also applies to all the parties who are in support of the applicant. Close of business today, filing and service. On our part, my lord, we do likewise, but tomorrow. If we are served by 5 or even 6, we should have enough time to file our submissions or any rejoinder affidavits before 4 so that we're able to serve our other friends. Effectively, therefore, it means that we are available, or we should be available, to argue this matter on Thursday. Let's not leave it to the last day of the week. Let's argue this on Thursday, and the time allocation could be agreed on Thursday, depending on the kind of issues that we'll have identified. Let's not agree on a time capping that this time, because I don't even know what solutions that are confronted. That would be our counter report.
My Lord, with respect, yes, I had qualified the plea by Malani Seniors, and I had said my flight was ready to take off, as the documents can ably demonstrate. I was ready for the trial this morning. I have to abort and disembark. Nevertheless, my Lord, I concur with what Malani Senior also has said, that if we leave it open-ended to have written submissions, it wouldn't also be fair to me, because I've already filed my own. I was ready to urge in opposition to the application. They are in
What have you filed?
Grounds of objections, yes, my list of authorities, and my written submissions. I burnt my midnight oil. They filed their application. I thought we should be ready to take off, but unfortunately they are not ready. And well, I would understand. We need to see what everybody else is saying. But that having been said, my lords, I also concur with what my answer is saying. And I think we should be very circumspect about that. Let's not go to Friday. Let's put it on Thursday. Also because it is expedient to ventilate this issue urgently. And lastly also, the issue of the time span that anyone is given. I think it's good to be fair, that we set it and that everybody knows I'm taking 15 minutes or 5 minutes. In fact, even in my written submission, I would only highlight salient features. I mean, and this is an application that will collapse on its head even before takeoff, for instance. So, my lords, I think the timelines ought to be set so that everybody coming here is fully set, so that we do not engage you with, may I have a further extension, may I have a further extension. We are all set. We come to highlight what your lordships already have. And when you retire, you will have a look at that. So it's not necessary for us to have open-ended timelines.
Okay.
Thank you.
So you're in agreement with Mr. Ngati about today, about the applicants filing their documents by today, but you're not in agreement that we shouldn't allocate time now.
No. What I was saying is the open-ended, he has ably put it. We should all come ready tomorrow, on Thursday, ready to proceed.
Okay.
Much obliged.
All right. Any other?
My Lord, if you may be allowed to say briefly, first of all, I think
before you respond, let me hear Mr. Is it Owoko?
Yes.
Yes.
What I'm saying that as far as this case is concerned, there's no house on fire.
There's no?
House on fire.
There's no house on fire.
Yes.
Many people may disagree with
And
you.
we must be able to articulate properly because we are looking for justice in this honorable court. What I disagree with is the issue of giving interested parties half the time what is given to the others. That's already showing a bias in this matter. If we say we are going to do our submissions within 1 hour or 20 minutes, it has to be across the board. That is justice for all. But what I'm saying is that if we cannot conclude by us, we can extend even to Friday. Because there is no emergency. There's nothing that has stopped that is not happening. So let us not be promised to burn the midnight oil as if there was a calamity that was coming, and that is coming. If that was the case, they could have come to this court long time ago.
My lords, on our part, we came
Name your name.
Mutuma for the fourth interested party. We came to court today ready to proceed with the matter. So we have no objection if the matter is pushed to Thursday. We would, however, request for clarity. We get to understand which parties are in support of the petition and who are in opposition of the petition so that we can know where we fall.
You want to know your friends? You want to know your
We want
friends?
to know who is on our side and not
Okay.
the other side.
Mr. Orengo, you're on your feet.
Yes, my Lord, I would want first to say that I would never want to misrepresent what we have agreed as council. I think Mr. Ngate is being very unfair to me because what I read out was after consultations. We talked to Mr. Thomas Sharia was here in time. Mr. Ngate was not here. We were here from about 9 o'clock. We didn't quite get the proper time. But I think it is wrong for anybody to suggest that I would stand here to speak on behalf of my colleagues and mislead the court the outcome of those discussions. And I want really that to go on record. Secondly, my Lord, when I was coming this morning, together with my team, we were even under the impression that your lordships may direct us to begin now. And my Lord, we would have been ready to do so. But after consultations, we felt in order to optimize on judicial time, instead of addressing the court without a summary of the substance of our submissions being put before your lordships in the form of written submissions, then you can proceed endlessly. Without the court knowing where we are starting and when we are going to finish. So all this was being done in order to manage judicial time. Now, as we speak here, Mr. Kinyanjui has not served us with the papers that he has filed. We have just been served in court when your lordships entered with this response from this first interested party. For the respondent, I'm sorry, for the respondent. In fact, all the documents that we have so far been served with have all been served today as we sit here in court. So we're just looking for a reasonable time within which to prepare our written submissions. And those will assist us in ensuring that we are as brief as possible in highlighting our submissions. My Lords, I think it is reasonable that we file by the end of the day tomorrow. We could have done so if we had been served with these documents this morning, at least before 9 o'clock. We would have sent our teams to start working on the submissions. In terms of the timelines, I think these are reasonable timelines. But again, if I may start from where I started, all this was subject to the court's directions. We're not saying that it must happen the way we did. So nobody should apply a sledgehammer on me. All this was all subject to the court's direction.
What about the suggestion to limit the page, to have a page limit on the written submissions?
Yes, the more exhaustive the submissions, the more we don't have to speak here forever. I think 20 pages would be reasonable. 20 pages.
That's a dissertation.
No, it's not a dissertation. 20 pages is reasonable.
Okay. Mr. Kalori, were you up? Okay.
Yes, my Lord. My Lord, I wanted to speak more on the issue of what the interested parties that have been doing have said, but before I reach there, I want to be fair to all councils involved. I think, first of all, when we appeared this morning, the first thing that we did is that we tried to see if the parties could agree on a timetable on how the matter can be canvassed. And what my learned colleague, the Senator, said is true that I was in that discussion, but it's also correct that Mr. Gatia and Ahmed Nassim, I think, were not present at that time. But my Lord, I think this matter, the importance of this matter is such that from my client's perspective, it is necessary that the matter is heard and concluded as quickly as possible. Not just because of the anxiety that is generating generally as a matter of public interest, but because it is necessary that my client is able to continue with its program with this matter having been resolved. And so a timetable that is set that enables this court to hear and conclude this matter as quickly as possible is beneficial, not just to my client, but I think the public in general. And so, subject to such modifications as the court may consider necessary, the respondent is prepared, my Lord, to proceed at the earliest opportunity that the court sets for the hearing of the matter. As regards the parties, my Lord, there are two principal parties. There's the applicant that has brought the application before the court, and there is the respondent who most of the allegations, my Lord, have been made against, and whose decision has been challenged. My Lord, it is necessary in the interest of justice that the respondent is given sufficient time to be able to respond to the allegations that have been made. And therefore, my Lord, the suggestion that time should be split equally among all the parties would, in the circumstances, my lord, not serve the interest of justice and will not be fair on the respondent, who requires to respond to a myriad of allegations that have been made. I am in agreement, my lord, that you do not need to write a long document so as to capture your arguments. Arguments can be summarized in short. And so, my lord, subject to such directions as you may keep as regards the length of the submissions in terms of pages, we'll be happy to comply with such requirements. I think, my lord, there's sufficient experience in this court to know that what length of submissions would suffice, because left to our own devices, we could write quite a little bit. So, that's all, my lord.
Is there anyone else who wants to say anything?
Yes, I'd like to say something, my lord.
Yes, Mr. Gatani.
Yeah, I think all parties, my lords, are agreed that speed is important. On the other hand, justice is more important than speed. And for this reason, my lords, the court needs to strike some balance to make sure that not only is the matter heard expeditiously, but on the other hand, the integrity of the hearing and the judgment to result therefrom is one where full arguments were allowed to be addressed to the court and the issues were sufficiently tackled. My lords, I and my team represent the printer. Who has been contracted to print the ballot papers. Going through the application, it is clear that certain serious allegations are made against the printer. And we would require more or less similar time that will be given to the applicant and the first respondent for purpose of dealing with those allegations. It's my humble submission, my lord, that taking into account the proposals made to the court, the first proposal remains better, where the applicant...
By first proposal, I mean Mr. Orengos?
Yes, Orengos, yes. Okay. Where the applicant, together with all those who support the application, would be filing and serving their papers by close of the day tomorrow.
Yes.
And all those who are opposing the application would put in their papers on or by the close of day on Thursday. And then we get heard on Friday. And I recall, my lord, the order from the Chief Justice constituting this bench, that there is a proviso that in the event that you need more time, you could sit outside, no more hours. And we're willing to help in that, so that if we go by that proposal, my lords, we should be able to be through with the argument by Friday. And who knows, if your lordships retire over the weekend, you could come up with that determination on Monday.
That sounds like a threat.
No, my lord.
Okay.
Yes. That's all I'd like to say, my lord.
We will take just 5 minutes in chambers just to think through this and come up with some directions.
Yeah.
I must warn you that Justice Mativo and I are in a 5-judge bench that's sitting on Thursday and Friday. And these dates have been scheduled for a long time, so we are not sure that we'll be able to get out of those hearing dates for Thursday and Friday. So we'll just bear that in mind even as we think through what we'll need to do. We'll be back in about 10
Perhaps before you rise there for calls, could we then suggest other dates for next week? Maybe Monday and Tuesday? Yeah, are you free?
No, once you come up with the directions, if that's where it leads us, then we will now agree on the time.
So we look
at that point.
Availability for next week.
Most definitely.
No, okay, we'll look.
Or the weekend. Or the weekend.
All right. Right.
Consultate our papers and give to the
It's becoming so elusive. No. We need it. No, man. All those things. And remember, email yesterday, this guy, the guy with the IT guy, the one we had the first time. The IT guy.
46, 45, 46, 47, 48, 49. Ni zako? Ne? Na za huyu ziko wapi? Hizi haziko hapa.